So Prosecutor Love, who had a family emergency because apparently her spa, I honestly don't know if it was correct or not. Well, 48 hours later, and this is what she came up with. I'll just.
And if there is a hearing where they give oral arguments, it's got to be her that argues it because she's the only signatory here, right?
Yeah.
So she wanted to keep this all to herself.
Yeah. Okay, state's response to defendant's motion to recuse Chief Judge Glanville in the trial of the above-styled case. Introduction. Midway through this now month-long trial, Defendant Jeffrey Williams and Defendant Damonte Kendrick have each filed a motion to recuse Chief Judge Glanville, hereinafter motions. The defendant has filed a supplement to the motions, hereinafter supplement. Now, this is, if I remember correctly, it's 81 pages, but it's only 9 pages of actual text.
Yeah.
Oh, no, I'm not. Yeah, I'm still 43 from the next shot because Brandon made it even, I think.
Uh-oh.
Yeah, he did. The state recognizes that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the 3 requisite determinations. Lie number 1. He made those 3. He made
reluctantly, but he did.
Yeah. He even did it when he denied it. He still said, well, these are valid, but then he evaluated the content, which he's not allowed to do. So he had on several occasions affirmed that the 3 prompts are met. So that this is lie number 1. Whether the motion was timely filed, whether any affidavit made in support of the motion is legally sufficient, and 3, whether if some or all of the facts set forth in the affidavit are true. No, wait a minute. Whether if some or all of the facts set forth in the affidavit are true, that's not the prompt. The prompt is
if assumed to be true.
You have to assume they are true. So that's not even a prompt. Huh. See, Henderson v. State, recognizing that once the motion to recuse is filed with a trial judge whose recusal is sought, that judge must make 3 threshold determinations regarding the legal sufficiency of the motion, whether it's legally timely filed, whether the affidavit made in support of it is. See here?
And then keep going, because the footnote continues on the next page too.
Yeah. But
and then we have an ellipses with.
Yeah, because these 3 dots here means there are text missing, which is not. So this changes the entire meaning of the prompt, and whether if some or all of the facts set forth in the affidavit are true. No, that's not the prompt. Recusal would be authorized if all 3 of these conditions are met. The trial court must refer the motions to another judge to hear the motion to recuse. If one of the conditions is not met, the trial court does not err in denying the motion. So she is knowingly misrepresenting the statute.
Because she's used to doing it and getting away with it.
She's so used to, yeah, exactly. Yeah. Accordingly, it fails to this honorable court to make those determinations. Miss Love. Hi. After reviewing the Shane Kendall case, it is my determination that you have no soul. You're empty inside. And you probably sacrifice lambs to Satan. I don't know. I don't care. It's my opinion. Go try to sue me. So, but as long as you keep lying like this, I mean, seriously, who are you to say I'm wrong in assuming that you're sacrificing lambs to Satan? Hello, I'm drunk, Nick. Let's see here. Let's set forth below. What, Fanny? No. Though defendant's motion and supplement are in part timely, in part, no, they are full part timely, and the affidavits in support of the defendant's motion and supplement are in part legally sufficient, full part legally sufficient. None of the facts set forth in the defendant's affidavits, even if assumed to be true, you have to assume they are true, and even if assumed to be true, would authorize recusal.
This part pissed me off, was she underlined none. And then it's like, we just watched the Supreme Court say that Christina Peterson messed up for holding someone in contempt for the maximum time period. We just watched them get mad at Christina Peterson for having her clerk having an ex parte communication about scheduling, really, but they just didn't inform the other party, which puts them at a disadvantage. If they miss a hearing, there could have been like a summary judgment. And here, you know, because it's Love, obviously none of those things would warrant recusal if it would not be in Love's favor.
Yeah.
That's really the logic behind this, because it's not reality.
Oh, it's factual background. Let's see how many lies she tells. The calling of the state's witness Kenneth Copeland on June 7th. On June 6th, in response to an inquiry from counsel for the defense in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th, 2024. That is correct. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland, and that Mr. Copeland would be asserting his Fifth Amendment privilege if called to testify on June 7th. Yeah, it's a longer story, but I digress. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Chart, Melnick copied Brian Steele and Max Chart on his communication with the state regarding Mr. Copeland's intention not to testify. Didn't we see?
She has it all jarbled. She has it all jarbled.
Yeah.
She was CC'd and she was accusing it of being accidental in the transcript for the ex parte meeting, but then she also attaches these emails as an exhibit. She could have just looked at them and gotten this part correct, and she chose not to.
Yeah. And because, was it you who shared it, or was it Thugger Daily? I don't remember. Somebody shared it. They are actually not CC'd.
It's attached in the exhibit. She attaches this to her own response.
Yeah.
And what's crazy is, guys, like when you CC somebody in an email, it's not a sneaky maneuver. You can look and see who CC'd in an email. Yeah. So, but she's trying to frame it for whatever reason as if it would be sneaky to CC someone instead of direct replying. Yeah. And it's not even accurate, but...
It's not even accurate, and even if it was, there's no foul play here because it's information that should be shared with the defense. So
it's just foul insinuation that somebody else is engaging in foul play and being sneaky and doing stuff behind Prosecutor Love's back.
Yeah. Let's see here. Copy, blah, blah, blah. In preparation for trial, Deputy District Attorney Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions. Which they had. Here's the thing. Last time the prosecution's team had contact with Mr. Copeland, he had representation. You always have to assume a person had the same representation on the next contact. If that lawyer then says, I'm not representing him anymore, I don't know who does, you have to ask him, then you contact him. But they contacted him directly without asking. Now, did Mr. Copeland actually say he had no representation? We don't know because nothing is recorded. All we have is Hilton's word on it.
But it wouldn't matter because they could have looked.
No. Yeah. They already made the boo-boo.
And let's be clear that it's Love in the writing here. We had some of it in the transcript, but here she's the one making this argument, right? Your own argument is in your own favor. It should be, at least. She kind of crosses her own signals here. But she's the one now saying that, all right, Melnick reached out to us. We hear from him after he got this announcement on June 6th. So she's memorializing that she didn't try to reach out to him.
Yeah. All right. And at no time did Mr. Copeland state an intention to plead the fifth or say that he was represented by Mr. Melnick. Here's the thing. Can Miss Love actually assume this without quoting Miss Love? No, Miss Hilton? I don't think so, because
she'd have to cite the investigator or Hilton.
Yeah, they have to have an affidavit from Hilton, or which makes them witnesses in the trial, by the way. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7, 2024. Coincidentally, he emailed them on the 6th. Morning of June 7th, they had the immunity deal prepared and signed by the judge, which seems to be, what's the word I'm looking for? Due immunity or something like that. Use immunity, which is far weaker than actual immunity. So the assertion they made in court to Mr. Copeland and in the ex parte
literally everything
was misrepresenting, like the just like Judge Glanville misrepresented the contempt. He couldn't separate civil with criminal contempt, and apparently the prosecution cannot separate between one kind of immunity with the other, which is insane.
I'm split on that, because I feel like I've seen them get things wrong, right? But then I also feel like they'd be willing to purposely misrepresent something to this witness they need to testify anyway. So is it incompetence or was it on purpose?
What's worse? I mean, I don't know what's worse of the two. Pursuant to this...
Actually, wait, one more point. Yeah. So they say cease communication with Mr. Copeland until June 7th, and they're very vague here. They don't give this timeline. But remember, Melnick said, and we're going to see in the emails, he had another hearing that morning. Yeah. So when they were speaking to Copeland that morning, if she resumed, Hilton could have been talking to Copeland again without Melnick there, because we know Love didn't know. When Love was standing in court, we watched that clip. When Love was standing in court, she was about to say, I don't think Woody's going to come and cooperate and get on the stand. And then the judge was like, no, hold on, he's coming in, here he comes. And then we see him walk in. So she was probably talking to him again without Melnick while he had his hearing. His other thing.
Yeah, they said you're super loud, so I lowered your mic a bit.
Thanks.
Pursuant to this, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extended immunity for Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granted immunity. Footnote 5. The court issued an order granting the state's motion. Footnote 6, which is just exhibits. On June 7th, after court was called to order, Mr. Melnick appeared before the court. Yeah, this is an interesting timeline because he didn't show up until after Woody started testifying.
I think he was in the courtroom. I think he was already in. Maybe. Maybe I'm getting it jostled.
Don't trust my word for it. I am a few shots in and a few beers in.
But in any case, you would imagine if you were in the right... If you're making the correct argument here, you would lay those details out. That's the point of a motion like this. Here's what happened. Here's the factual background. But we're not getting her laying that out. Why not?
Slick to favorite TV for $1.99. Sorry, I thought I hit the 100 too many shots.
I love that.
But that brings us to 41 to the next spin. Dun, dun, dun. Mr. Blah 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 before the court and informed the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination in the presence of each defendant currently on trial and each of their respective attorneys. Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order to the court pursuant to OCGA, directing Mr. Copeland to testify and extended immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland in the presence of every defendant currently on trial and each of their respective attorneys that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Mr. Copeland thereafter stated his intention to testify, and Mr. Melnick looked towards Mr. Steele and Mr. Shod and shrugged his shoulders. I can't. I've been watching that 16-minute clip. I can't see it.
I didn't see it either.
And even if he did, so damn what?
Yeah, because the whole clip she's going.
Yeah.
Like, are we gonna like make a point of body language in one direction only?
Now, even if this happened, okay, during, if I remember correctly, what's his name? I don't remember. What's his slug or tick or?
Oh, Jontavius Stevens.
Yeah, during his testimony about, they are Bloods, aren't they? And both Hilton and Love are color coordinated in red.
No, like Ray was like salmon and orange.
Yeah, I mean, well, it's all red to me. After motions hearing, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. So damn what? So what? After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland shakingly answered a few questions, and when asked his age in years, Mr. Copeland responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody. Here's the thing about Mr. Copeland's Fifth Amendment thingy at his age. I don't think that would have survived an appellate issue because it's not damaging when it's against his age. And this is just one of many mistakes from the prosecution, maybe speaking more to their incompetence. I
think it's just more that he probably told them.
Yeah.
Because why wouldn't he tell them? Because his goal isn't just to say what he feels like is the best thing for him to say in any given moment. He doesn't want to get up on the stand at all. So he's going to tell them, I don't want to testify. I don't want to testify. I'm going to plead the fifth. I'm not going to answer. We're going to take that away from you with this use immunity deal. If they didn't explain it, he probably thought he could just go do the same thing. Or he decided, I don't care if you told me I can't do it anymore.
Yeah. And he was more or less read between the lines. I mean, what's going on in the chat right now? No, what? In open court, in the presence of all the defendants currently on trial and in the presence of each defendant's respective attorneys, Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June 10th, to allow Mr. Copeland to purge himself of his contempt by testifying. Mr. Melnick announced that he was going on vacation. Here's the thing. You advertise to the court when you are not available. And now, this would be really hard to plan this way because every witness has taken so long. But it does seem like it was somewhat planned. And even if it wasn't planned, they could have just taken another witness.
Or they could have taken the day off because they've taken so many other days off. Yeah. So why is it a problem to suddenly wait? I don't know if Melnick was gone for a long weekend or a full week.
No,
if it was just a long weekend.
A full week. And, I mean, they had plenty of other witnesses in the Donovan Thomas case to call.
They could have reviewed the video footage until Melnick got back.
Yeah, definitely. But they didn't. June 10th, 2024, meeting regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. The ex parte meeting. On Monday morning, prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Kenneth Copeland and the court, and an attorney for the state. This is just so stupid. Now we are going into stupid mode from the prosecution, because it's an ex parte meeting and there are specific rules setting for ex parte meetings.
And they should be arguing it.
Yeah.
They should be arguing the exception here, but they're dancing around it.
Yeah. Hey, Sean Lee. Hey, thank you for your gifted memberships. And it was given to Breaking It Down with B, Road Dog, Tall Glass, Cavill, and Politicking with Mel. You now have access to all my members-only content. And first of all, it's a lot of it. And most of it has nothing to do with law. It is about me, the farm, the renovations, and stuff like that, so we get to know each other better. So that is the members-only things that's on my channel. Yay! So thank you so much. And that brings us to 41 minus 15 is 26. Yes, it's $3 a month to become a member, because I'm not comfortable with high membership fees. I think $3 is reasonable. But thank you so much. Thank you so much. Where were we? On Monday morning prior to the start of court, blah, 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 blah. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting was CDDA Love, Attorney Kayla Bumpus, investigators for the state, and the Honorable Chief Judge Glanville, and later Kenneth Copeland and DDA Hilton. Matters addressed during the meeting concerned only the contempt proceeding against Mr. Copeland. So watch. So fucking watch. We are 2.5 hours in.
I mean, they also kind of involved life coaching advice on how to talk to your nephews.
Yeah, and
for being honest.
And the judge giving legal advice and a bunch of other stuff. Which, I mean, ex parte meetings, if I remember the statute correctly, are presumed to be bad. That is why even if you want to have an ex parte meeting, you have to inform the people involved. This is what the meeting is about. At the absolute latest, after the meeting. That way, and then hold a hearing about, we held this hearing, this was the content, da 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 da. But what did Judge Glanville do? What did he do? Who told you?
Let's get started. Let's call the jury and anything we need to address first. Oh, I have an inquiry.
Yeah, I mean, Judge Glanville went full rooster. I mean, I might say rooster, I mean another word. And just started pissing all over the courtroom. And I mean, he was in full rooster mode there. Who told you? One of the sentence, it was just a few words. You were not supposed to know this about the information. And his intent, Judge Glanville, was to release the transcript after the trial. And why? Because Judge Glanville knows that an appeal in this case is a multi-million-dollar thing. He knows this. The transcript alone in this trial will be insane.
He'll kill a rainforest to print it out.
Yeah. Do we have shots to it? Oh, crap. I see something in my PayPal. Oh, $26. Thank you so much.
We can do that math.
Yeah, I can do that math. Oh, I remember a couple of months ago, Brandon said, "Oh, yeah, you have something in there," and he bought every slot in the Wheel of Regrets. I have vague memories of the last few.
Oh no.
Thank you so much. Thank you so much.
I had a bad Halloween many, many years ago, and I woke up I had a Black Widow costume, and I woke up with like my shoes on and everything, just like at home asleep, just in my costume.
Yeah, but
luckily it was a comfortable costume.
Yeah, sometimes you just want to go home. That's it.
Sometimes that happens when I'm sober, and I'm just like, I just want my bed. Bye.
See ya. Bye-bye. All right. It's the wheel of regret. Let's see here. It is a vodka shot.
Well, if it didn't stop at the other one, it would have been a vodka shot anyway.
There's glass. Jesus Christ. Oop. Oh,
the wheel is great. I think everyone should have one.
Mow in the Deep one has Mow in the Deep End has one for wigs. Okay. For fuck's sake. Okay. If you are sensitive for foul language, you should leave now. This won't get better during the level of intoxication. All right, and hide that choice. Whew. Dun, dun, dun. Hiccup soon. Well, we haven't gotten to the hot sauces, so not yet. Not yet. Now we are $50. Now, PayPal has a discount because YouTube takes 30%. PayPal only takes 2 to 5%. So $40 on PayPal. And again, if you write Gigi in the PayPal, that will be sent to her.
Shout out to Gigi.
Yeah,
Gigi is really nice. I like chat with her a lot when I'm in the chat and not on the screen.
Yeah, and she's my first and best moderator. I mean, yes, she sometimes drops her phone behind the sofa and accidentally mute people. That's just part of the fun, but not lately.
She butt dials it.
Yeah, so she's not as bad as Jeff, who managed to shower ban people because he was in the shower and a drop of water got on his phone, and I called BS on that one because that was
that actually does kind of suck though. Like if you get a water droplet on a touchscreen phone, it just does what it wants.
Yeah. Whew. Where were we? Madison about that Mr. Copeland and the topics addressed, including topics Mr. Copeland's rights and representation as it relates to the proceedings. Yeah, I mean, it's not an outright line, his rights and representation, because was it Hilton who said you can talk to me without your lawyer? So it was a matter of representation. It was an illegal one or an ethical one. I mean, yeah. But just to make things clear here, this immunity paper, I don't like it at all because the Fifth Amendment, the U.S. Constitution and Bill of Rights should not be eradicated by a piece of paper from a local court who says, you have immunity. No.
Trust us, wink, wink.
Yeah, trust me, bro. It's so insanely stupid. Blah, 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 and answers to question posed by Mr. Copeland regarding matters related, such as the distinction between purging oneself of contempt as addressed by this thing and perjury as prohibited by this, with the exception of the times where Mr. Copeland afforded an opportunity to speak with Miss Bumpers alone. The entire meeting was taken down by the court reporter. Lie. Number... I don't care. And here we come to the clutching pearl moment. I'm offended. Oh, yeah.
Well, and she didn't make any argument to defend what she's supposed to be defending right here.
No.
She's just griping.
Yeah. It's filibustering, more or less.
Yeah.
Yeah. Brian Steele's defiance of the court commands and subsequent contempt ruling. Oh, jeez. Miss Love. Between you and me and a bunch of 300 people over Twitter and here. Nice. Hey, hit the thumbs up, folks. Between just you and me, Miss Love. No, I can't say that word. It starts with a C. After the meeting regarding Mr. Copeland's contempt and obligation under this rule, Brian Steele stood in open court and demanded a mistrial, clutching pearls by Miss Love. And as he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. Oh my God! Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal Mr. Steele's source of information regarding in-chamber matters.
It's just crazy because it's also the reverse, the implication of that disobeying. It's stating that he should have divulged something that could have been attorney-client privileged information.
Yeah, it's insane.
In open court, without, why don't we call an ex parte to have the defense speak with Judge Glanville?
Yeah, I went through the rule, I believe, what was it, 5.3a of the Georgia Rule of Conduct and the commentary to it. Because you can not only read the rules, you have to read the comments as well. That way you know how to interpret it. And it clearly says he can't reveal it because that would be a violation of attorney-client privilege. The attorney-client privilege that didn't occur in the ex parte meeting, by the way.
And then also with Merchant and Souser and then his wife, Colette Resnick Steele, they also added in, and for other reasons, potential if needed, right against self-incrimination. So they added that in to cover a full stop. So, and what I thought was so great about that is this whole issue stemmed from someone trying to plead the fifth.
Yeah, I mean, it's so stupid. Here's it. See exhibit, see transcript, see exhibit, blah, blah, blah. Matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Kemp in contempt of court. After defiantly and repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. I have so many words that I want to say, but even after
he's not the only one that filed the motion. He's not the only one that filed the motion. Yeah. She has to combat multiple motions here. And she's not.
Yeah. And do you remember what Mr. Davis? No, his co-counsel, Mr. Steele's co-counsel, his name is Mr.
Adams. Keith Adams.
Keith Adams.
He said hold me in contempt too.
I have the same information. Well, I didn't ask you. That doesn't matter. If he has the same information, his co-counsel to Mr. Steele, the same rules that Judge Glanville tried to apply, applies to him as well. But I assume Mr. Glanville knew, this would look really bad. And then
in that case, the flip side of that, it puts him in the catch-22 where now it looks personal against Steele, which I do think in part it is. But I'm just saying, Adams caught him in that. Adams doesn't get enough credit. Adams is really great.
Adams is because Steele takes the brunt of the force, and then Adams shows up once in a while to make that extra. And that partnership there is amazing.
I agree.
You're alive, and I'm a legend. Yeah, sure. I don't mind at all. Grab some moonshine. I don't have moonshine. I have to go back where I grew up to get the proper moonshine. for you who don't know, I grew up in the mountains, the woods, the small lakes and stuff. And as I said before, I'm this. I'm not just white. I'm comically white. This is 1,000 years of successful Scandinavian inbreeding. This is, yeah, shockingly Caucasian. And where did I? So I grew up in the parts where we actually make moonshine, which is highly illegal in Sweden. Well, it's
We just
highly
had a
illegal.
ruling here. I forget
Oh,
where or what the case was, but it's now okay for us to distill our own whiskey at home. Something like that.
folks, you need to subscribe to my channel and start donating more so I can retire to whatever part of the United States there.
Wait, it's moonshine in our bathtub. Hold it better. Oh, wait. I just linked your channel because I didn't copy and paste the thing.
Oh.
That's hilarious. It's 10 hours ago.
10 hours ago. Wow. Oh, there it is. Thank you. I need to read.
So, guys, on our next stream, we're going to make bathtub moonshine.
Oh. Federal judge finds American has a constitutional right to distill moonshine in their bathtub. A federal judge rejected a more than century-old ban on home distilling as unconstitutional Wednesday. Judge Mark Pittman, I don't care who was appointed by, found that a federal law making it a felony to distill spirits at home exceeded Congress' power, holding that neither Congress' tax power nor its ability to regulate interstate commerce justify the ban. Pittman, that's a legend, permanently blocked the government from enforcing the ban, which threatens violators with up to $10,000 in fines or 5 years in prison against the plaintiffs if found to have standing. Quote, indeed, the Constitution is written to prevent societal amnesia of the defined limits it places on this government of and by the people, Pittman wrote. Quote, that is where the judiciary must declare when it's co-equal branches overstep their constitutional authority. Congress has done
co-equal?
So.
There should be a hyphen there. It should be co-equal.
Okay. Sure. President Jimmy Carter signed a law that legalized homebrewing in 1978, but the distilling spirits at home remained illegal. I don't claim I do know this, but I do know if you have about a foot of tube, an old teapot, and a jar of ice, and under it a can, and know the recipe of what later becomes moonshine, I know how to build one.
I make pickles at home sometimes, like the fermented kind.
Yeah.
And the fridge pickle kind, but it's fun.
Now, the main issue is temperature, because if you make this small kind of an apparatus, it's really hard to get rid of all the things, and you then have to run it through active coal quite a few times to make it drink. Allegedly, after everything was said and done, I had to make it into banana liquor to make it drinkable. But hey, 60% banana liquor is also drinkable. Allegedly. It's all hypothetical, folks. It's all hypothetical.
That sounds gross. Banana.
I'm not
60%.
I'm not saying I'm a redneck, but I know some. We Swedes have redneck too. Have you heard the story about the man caught pleasuring himself while carrying a canoe?
What?
Oh, you haven't?
Carrying a canoe?
while carrying a canoe. A man in a certain part of Sweden, the cops got a phone call. There's a man wearing a leopard skirt, being very excited. So the leopard skirt had a rice in it at the local recycling station. The cops got there and they found him carrying a canoe and intensively pleasuring himself. When caught, he claimed to the police, "No, I only have an itch."
I mean, that's a quick lie, I guess.
Yeah. Now, that in itself is quite funny. This is 45 minutes from where I grew up. So chances are I either know the guy or I'm related to him.
I just gotta like go like this. Like, I don't know you.
Yeah.
Well, there was that guy in Philadelphia yesterday too, who like nutted on a girl's leg in a store, and they caught him yesterday. They arrested him yesterday.
Yeah,
that was disgusting.
Yeah.
Like, I just can't even imagine. And like, that's not the only time I've heard a story like that. But it's just like, how do you get to that point when there's like the internet?
No, Ghost, it wasn't me. I don't wear leopard skirts. Where were we? Let's try to get through this. Thank you, Just Oni. Oh, there. Yeah. Drunk me has much better stories to tell than sober me.
And that's when more stories are created.
Number 3, argument and citation of authority. No, quote, fact set forth in defendant's motion or supplement authorities authorizes the recusal of Judge Glanville.
And that's bad grammar, too. She's forgetting about the multiple motions. She even said she's going to call it motions, but she's so hyper-focused on Steele that she forgot that she was fighting motions.
Yeah, and here she quotes, "To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in this case." Emphasis added, clutching pearls. Quote, "There is a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the fact asserted authorized recusal." And here are the dots again, where she conveniently forgets things. Questions of law. Here, with the exception of the defendant Williams' untimely allegation. Untimely. Even all of this hinges on that Miss Love believes that Judge Glanville is incompetent because he made these findings himself. Singly, here, with the exception of the defendant's Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared. 3 times he yelled at the defense with the jury present. Now, yes, 1 for Steele and 2 for Mr. Charge. But that just shows her bias against Mr. Steele, because the other occasions was against Mr. Shard. Excuse my accent. And here again, she doesn't actually quote. She only refers. Because she knows if you look into these, it doesn't actually say what she claims it say. Defendant's motions and the supplement are based entirely on the defendant's assertions regarding June 10th, 2024 meeting regarding the contempt proceedings against Ms. Kenneth Copeland and actions taken by Chief Judge Glanville after Mrs. Steele defiantly refused to comply with the repeated request to provide the court with information. GA Code of Judicial Conduct 2.9 regarding ex parte communication provides that, quote, judges shall accord to every person who has a legal interest in a proceeding. Let's see here. Remind me, Kat.
Who has the rights according to the Constitution?
Yeah. And remind me, was Mr. Copeland sworn in?
He was sworn in, and it was a critical stage of the trial.
Yeah.
So this is the problem with this, right? This argument should be, it's not a critical stage of the trial. Here's why. Yeah. There wasn't an interest for the defense to be present at the party here, the ex parte. Here's why. This ex parte fell within the exceptions. Here's why. That's what this argument section should be doing, and she's not. And even things like Mr. Steele defiantly refused to comply with the court's repeated request to provide information. She should be specific and say to reveal the identity, and then she should make an argument, whether it'll land or not. She should make an argument that he couldn't hide behind attorney-client privilege. But she doesn't address any of the arguments she's actually supposed to address here.
No. Or that person's lawyer the right to be heard according to law. Emphasis added. However, clutching pearls intensively, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify, except the content of the ex parte meeting, including but not limited to, I did the crimes. What crimes?
These. Just generally.
Yeah.
Because these refers to, like, here, these, things in front of us. In other words, the inference would be what's involved in this case. The crimes in this case, these.
Oh, I did these crimes.
Not those over there in another case.
These. Yeah, exactly. And it's so... And
then there's also other problems because Doug Weinstein stood up in court that day and was like, and quite frankly, we're still in the dark. And then his motion, he ended up having an affidavit later, but there is no claim, a standing claim that Love can make saying, well, they did find out when Brian Steele made the inquiry, right? That was only minutes after we came into the court, so it wasn't that bad. It was prompt disclosure. But no, while Glanville still focused on prodding Brian Steele to reveal the identity of the leaker, the other defense attorney's like, quite frankly, we're still in the dark, which means no disclosure was still made.
Exactly. And here he quotes Allen v. State, but not... And what the court might have preferred that a key witness not be ordered to testify truthfully in his trial. There is nothing in Georgia law that would have permitted him to object to the state's request for the order, or that would suggest that defendant's right with the subject matter under consideration. But this is out of context. I mean, compelling a witness. Yeah, but if that was all it was, but it wasn't. It was the judge giving legal advice instead of just shutting up and make rulings. He didn't inform the defense that it actually occurred. And his plan was to not inform until after the trial. Then you have the content where Miss Hilton gave immunity even if he lied on the stand. You can't do that. You can't give immunity for perjury. The immunity standard does not apply to perjury. And she gave it. So more or less, you have Judge Glanville, you have Miss Love and Miss Hilton. That's three people conspiring to break the law. In Georgia, that is a criminal conspiracy under the RICO statute. Just saying.
And I'm also up there, like the paragraph, it says a brief hearing.
So 2.5 hours.
And in the footnote, it says brief hearing. So what she's citing, she quotes in her footnote. It's like the fifth line down in the footnote. Improperly by conducting a brief hearing outside his presence. This was a long meeting in chambers.
Yeah. A brief hearing is Hello, can you make the 12 o'clock on...
Did you address that order yet? We wanted you to... Did you make an order yet on this request we sent you?
Yeah, that's brief. This 2.5 hours, that's not brief.
Because look what it says. It says concerning the state's request for an order. They really could have just been saying, did you get to that yet? Did you rule?
Yeah.
That's what the context could be.
Since no defendant in this case had a right to be present on the June 10th, 2024 in chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceeding against Kenneth Copeland, the fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted, 10th day of July 2024. And what the fuck is that font? She changes the font for her name. What the...
Is that the same font she used for her email signature?
I think so.
I mean, this whole response was asked because she already had the chance to see how Krause made her 2 other rulings. And I'm sure she can look at other rulings Krause has made. They work in the same building. Krause is looking for the argument to be made. She can't respond to something if the argument isn't made. And she's also looking for the case law, what the law says. And here, Adrienne Love does not address the arguments that she's supposed to be countering. This filing is a response. It's supposed to counter the things that are in the other motions and in the supplement. What are those things? Because they were well substantiated and backed by case law and well argued in the other motions. There was an ex parte meeting that violated the exceptions of when an ex parte meeting can be conducted. Did she address that in here? She doesn't even try to say that Kenneth Copeland was scared for his life. It might kind of come up in an attachment, but she didn't argue it. So if she didn't argue it, what's Judge Krause going to say about that argument? If she weighs the defense's arguments on that point and then tries to find the counter argument and it's not provided. It was a waste of 9 pages of paper and a 48-hour delay.
Let's see what